expeditiously in response to the need.
It's my understanding that if this becomes law January 1st of next year, that the infrastructure is in place and that they can make the installations as they become necessary.
Okay. And I noticed that motorcycles were exempted from this. We have these new tricycles, if you want to call them that. They're actually cars with wheels, 2 wheels in the front, 1 in the back. Has there been any thought of including those because they're being ridden around like cars?
I haven't thought about it, but
But I would hope that you do that. And if you are going to be amending the bill, I'd also like to be a co-author, if that's okay. And, you know, alcoholism in many cases is an illness. And I just want to give one example of a gentleman that only wishes that we had this law in the books at the time that he was put away. This was a guy that was a very successful real estate agent, broker in Temecula. His name is Tom. And I knew him for years because he used to volunteer his time for the Boy Scouts and do all the auctions and raise money. And he used to come in my pharmacy and he said, "You see all those hills out there, Jeff?" I said, "Yeah." He says, "I own 6% of them." So he was very successful in marketing and selling real estate. But there was a very quiet problem that he had that nobody wanted to address with him. And that was that he was a heavy drinker. And one Christmas season, he was at a home and having a party with all of his real estate agents and drank excessively. And many of them said, "You know, Tom, you really shouldn't drive." And him being kind of an arrogant drunk, got in the car, went through a stop sign, and killed a family. And it was not his first DUI. And one thing they tell you in Riverside courts, after your first DUI, they tell you, at least our district attorneys give the warning, that if you come back here again with a DUI and you kill somebody, you're not looking at manslaughter, you're looking at murder. So Mr. Tom was convicted. Family man, destroyed his family, of course destroyed another family, and he's still in jail, 25 years to life. Had he, I'm sure, wished that he had this type of infrastructure in place because he had a problem that allowed him to continue his dangerous activities while under the influence. And another incident I just want to share with you is a pharmacist. I was in the area, and we had a very popular dentist. He was the first dentist in Temecula when I got there in 1983, and he had 2 beautiful sons. And tragically, I got a call one day that his firstborn son was killed in Temecula by a drunk driver that went on the opposite side of the road. And if that wasn't tragic enough, 4 years later, in a separate incident, his second son was taken from him by a drunk driver. So in Southwest Riverside County, we have a wine country. We sell a lot of wine, and as a result, we have a lot of DUIs. And on the city council, I put forward a lot of initiatives, one called Operation Erase It, Enforce Responsible Alcohol Consumption in Temecula, sending decoys out to make sure that retailers weren't selling alcohol to minors, and putting arbitrary checkpoints up. And we pulled so many drunks off the road. We made it very clear that we had zero tolerance for that. So I come from an area where I've seen a lot of morbidity and mortality associated with people that are drinking, people that have a medical problem. And this is going to inhibit a lot of these people that have medical problems from getting in the car and killing innocent people. I applaud you for bringing it forward. I'm delighted to support it. Anything I can do, please let me know, and happy to move it if nobody else would want to.
Thank you. Senator Anderson.
Bill's been moved.
Oh.
I'm sorry.
Thank you. Thank you. Senator Glazer.
Thank you, Madam Chair. Senator, thank you for your leadership on this issue. I appreciated the time you've spent with me answering a lot of my questions. Mary, my heart breaks to hear your story about Matt, and I appreciate your tenaciousness to lead this effort to make our streets safe for so many others who to avoid the tragedy that your family has experienced. The only question that that remains with me, Senator, is this DMV study, and why it's taken them so long. It was the understanding and the extension of your bill a year ago to wait for that study. What is DMV's answer to is there a representative from DMV here to give an explanation to us about why that study's taken so long?
You know, I could probably just also say, because I'd like to focus that question a little bit, they did do a study on general deterrence, and they found there was no general deterrence, by which I believe that meant that first-time offenders did not go down. Okay? They now want to do, they are now working on, and I would have thought they would have had it by now, a study of specific offenders, i.e. if someone is convicted and they have an interlock device or they don't because the other counties are used as control counties, does it keep them from reoffending?
Yeah. And if I could just expand on that a little bit, the general deterrence is if you drink, do you know that, are you aware of the requirement that you have an IID, that it is a requirement of law? And that's really what the general deterrence is. Does this deter someone from drinking? Just by knowing the fact, but no one knows that there is a law or was in the 4 counties that we were talking about. So really, a general deterrence is meaningless in terms of giving any help. So what we're looking for, and I'm willing, if the bill moves today, and there's support for that, I'm willing to let's wait when we get the report. Let's come back, and we'll be happy to sit and see how we can adapt and make modifications to the bill if necessary that will reflect whatever we learn from that report. But I think that's the best way to go, but I don't think it's reasonable to expect us to wait another year without protecting the lives.
Just to follow up, but the issue of deterrence is not really the essence of the problem, which is that you don't want people to get behind a wheel with any amount of alcohol if they've had a previous conviction. In order to, it's not about getting caught the second time. It's about that it's just preventing it from happening, period. And so the interlock device actually stops them at whatever level. It's not about whether they get caught another time. Isn't that right? I mean, so is the study just off in terms of the essence of what you're trying to accomplish here with your bill?
That's true, and what we're trying and what the study that MAD conducted and the results would show that over the last 5 years, while the pilot program in those pilot counties, it has prevented those starts of vehicles over 1 million times of people who had been drinking before they were driving. So it actually saved, and when you think of the 100 and some thousand of those who were 0.08 or greater in their blood alcohol, the lives that could have been saved just from that, I think is expanded. Thank you.
Thank you. Senator Leno.
Thank you, Madam Chair. And thank you, Senator Hill, for all of your office's assistance in answering our many questions. And Mary, it's good to see you again.
Thank you.
After our many, many visits,
yes,
both to my district
it's very good to see you.
And capital offices. You are
very persistent.
Your tenacious is as beautiful as it is strong. So we thank you for that.
It's my son's legacy. He took the oath to serve this country, and I intended on it being in a different way, but I believe that his legacy is going to save more lives in what my husband and I do.
That's because of your strength together. The analysis asks a couple of curious questions. With regard to current law and what is required on a second DUI relative to mandatory suspension, that the suggestion was that this is on page 7 of the analysis under point 5, that a person with a second DUI immediately installs the IID and does the mandatory time for 12 months, but would then still have an additional 12 months to serve out their suspension. Would that individual, having complied with the 12 months, would the IID removed and still have a drive on a restricted license? So there's my understanding, there's a 24-month mandatory suspension on a second, but the IID would remove the mandatory suspension. So
that would be my assumption, because I mean and I'd look to the committee staff to see if that's their impression of that, because to me the goal is to, if a person is on license is suspended, the goal is to have them that reflected in an IID in their vehicle.
Well, I think the issue is if you're potentially getting rid of the hard suspension by having them install the license early, but you only require 12 months, they technically have a 24-month suspension. 12 is hard, and then, so there's going to be time frame difference. I don't know if you're extending their time of their interlock by the hard suspension. It needs to be, I think it needs to be clarified what you intend, because I think the intent you have is to have their interlock on the entire suspension time, but now you're allowing them to install it earlier during the hard suspension time, so their time frame is going to start earlier. I just think that at some point that clarification.
Yeah, and I do need to clarify that and be brief.
And on hard suspensions, I don't really think there are hard suspensions, because hard suspensions, the court usually always grants a reasonable request to go to and from work, or.
Hard suspension's a DMV installed inspection. It has nothing.
Right, but in terms of how they function, how it plays out in terms of what the court does, the court lets people drive only to and from work, notwithstanding, I mean, as sort of a carved out discretionary exception. I've seen people be allowed to drive. And I think the ignition interlock device would then simply temper that in the sense that
hard suspension often starts, I'm sorry, but I think she's misunderstanding. The DMV hard suspension often is, especially for first offenders, has fully been implemented before you ever see them in court. So it's different than the to and from work exception. There's the layers of the DMV required and the court, and the to and from work exception often happens after the hard suspension has already passed.
What I'd be happy to do is work with you to get that clarified, to make sure that we're consistent with what the intent is. And I mean, the goal really is, if the time that you would spend, it would be with an IID and not a suspended license to allow someone to get into the same situation.
So thank you. I thought that's what your intent was, so let's
okay, we'll make sure it's clear. Thank you.
And then with regard to the costs, I've read a variety of ranges. So we've heard on average $4 a day, 3 to 4. Let's take the higher end. That's about $120 per month. But then I also saw, and that's the total costs, installation plus monitoring and operations. But then I also read about $100 installation and then $50 a month. So that's about half of the earlier estimate. So does it depend upon the installer you choose,
and I do not know what the difference is, because I've seen $50 to $100 for installation, right, and $80 to $100, I think, for a month, or $50 to $100 or $10 per month. So significant. I guess there's a range.
Does the defendant have a menu of options of how to go about getting an IID and who the best installer might be, or who the most
Mary may have the answer to that.
Cost efficient? How does that happen?
There are 17 vendors in California that are NHTSA approved, and the higher end, such as my car that's out in the front of the Capitol today, has a camera included in it. And if judges' discretion is that these people have violated frequently and they need to be monitored with a camera, that is actually more expensive. So mine is approximately $53 a month, and it was $125, $30 to install.
So with this bill as law, the court no longer has the flexibility as to whether this will be installed. It will be installed, but there's still some discretion within the court as to what model and what kind, including camera or not. Is that accurate?
Yeah, I don't know if there may be the requirement for a camera if there are violations after that first offense that would apply.
That would be the court's discretion.
But I would think if we took it at the court's discretion, but if you take the highest cost of $100 a month, and if you look at the rate schedule that we have put forth.
I get that. I'm just trying to, how it will operate in the real world.
Yes.
Am I going to pay $50 a month, or am I going to pay $100 a month? And who decides that?
Right, and that, I think, would be, and here's a gentleman who, please.
My name is David Nico, and I'm with Lifesaver of Northern California.
Excuse me?
I'm sorry. My name is David Nico, and I'm with Lifesaver of Northern California. I've been a certified provider in the state of California for 23 years. So maybe I can shed a little bit of light on how this works. With respect to which provider that particular individual goes to, there's a wide range. As Mary said, I think currently there's 18 to 20 providers on the list. So that individual has the choice to call the various providers and shop it. I know with our business model, we do not charge an installation fee. It's a monthly fee. It's all inclusive. That includes the monitoring, calibration, every aspect of that. With respect to the camera unit, like in San Joaquin County, you have a DUI court there, and Judge V, I refer to him as Judge V because I can't pronounce his last name properly, they prefer the camera unit. And that is it's $10 more a month, so it goes from a $75 basic unit to an $85 unit, and that is because he prefers that particular device in that DUI court. In that DUI court, the camera unit is part of the protocol of the monitoring system in place, along with SCRAM and some other monitoring devices. But he prefers that because we're able to take a snapshot and see that individual and verify that individual for evidentiary purposes if that individual has to come back to court.
So what is your understanding of the bill as it is written? Will the court still have some of this discretion, or it's all going to be put upon the...
Yes, I don't see that discretion being taken away with respect, especially with the insurgence of the DUI courts that are popping up. I think San Mateo County has one as well. I don't see that discretionary aspect being removed because the DUI courts, they have a different protocol with respect to what they're requiring as to monitoring. It's a little different system, but I don't see that being gone.
It would be like, as we do with traffic school today, there are a menu of choices, and you can go to comedy school or not. And so I think that would be the same to offer that same opportunity with shopping.
There would be.
We might want to get, again, some greater clarity, especially, and I very much appreciate the graduated scale. So even on the high end, if it were $120 a month, and I'm just at the federal poverty line, I'm going to be paying 10% of that. So that's $12 a month, which on my $24,000 a year is still something. But I also recognize I'll probably save at least that much in the purchase of my alcohol, $12 in a month's time. So it's maybe going to be about a wash.
Yes.
So I can live with that just fine. But if I can also get it for $60 a month, I wouldn't mind knowing about that if I could. I don't know
we'll
if
clarify that, absolutely.
Some way, and I don't want to add any additional costs to the bill to impose anything upon the courts, but just some way of getting some basic information out for people who may not be in the best position to do some shopping. And then I think I have one other question for you. On page 8 of the analysis, it makes mention that there'll be a reduced fine if the interlock is installed early. The savings of $500 off the fine.
Yes.
Will the court be informing me when I am convicted that if I install this early, I'm going to have the opportunity to save $500 off my fine? Is that how that's going to work?
Well, I would hope that that would be automatically done through the court at the time that it occurs.
Probably too late by the time you get to court because it's during the hard suspension time. So by the time you get to court, it's probably too late.
So where's the best way for me to find out I have an opportunity to
save $500? We want to make sure that that is imposed at the earliest, and they would
again, just
there has to be a way of making sure that that's very good.
That would be an amendment.
I'm not suggesting
moving forward,
but just
no, I think that's a valid point. We want to make sure that they do, because they are taking advantage of the IID program early, that they should be able to benefit from that financially. I agree. So we'll make sure. Thank you.
And lastly, as I do support the bill today, I want to suggest I would like to see one amendment, and that would be for, since this is a massive expansion, and for good reason, but there could be unintended consequences. At least one was mentioned earlier, which is the oversight of what's going to be a much larger industry, and we want to make sure consumers aren't being, are getting their money's worth. Because it is a technology, and technologies can fail, and maybe someone's in the market and is approved, but they've got a lesser model or less effective. There could be other unintended consequences. Might we look at a, let's say, 5-year sunset to the statewide expansion with a report back to us so that we just can keep an eye on this? And I would imagine with all the success that it's already had, that the legislature would there be the political will to extend it, but also maybe make some fine adjustments if necessary.
Okay, may I look at that and see? I'm just thinking with waiting for the DMV report to come back, and when we finally see that analysis, that'll give us a chance as the committee to look at it and see if there are some changes that we could make, because I guess I look at the the 4-county pilot that I would think has looked at those issues, but you're right on the technology and the availability. But since there are 18 or 20 companies around, I would think that the availability and the technology would, especially with the competitiveness of it, would make sure that it's there. But
my concern isn't so much that the provision of the units will be available, but that over the years that we again, without adding costs to the bill, but we want to have some ability, the legislature to have some ability 4 or 5 years out that something hasn't gone off course with regard to all of this proliferation of a technology.
right. No, I know, and we want to make sure this stays.
Madam Chair, should the bill move forward today, is it understood that the bill automatically comes back to the committee after the DMV review? No, it's only if there are recommendations you said you're going to take.
Yeah, no, and I wanted to make sure that the committee was part of that, because we've had that conversation last year, and I want to make sure that we hold to that, where there's some reflection of that in what occurs. We were hoping, obviously, that it would be back by now.
Okay, yes, we were.
I'm just going to make the suggestion. I would personally like to see a sunset.
Okay.
I'm not set on a particular number of years, but again, it's expansion of a very major way of a technology and program that I think makes sense.
It is.
Just to have a look at it.
And I agree. It is something that
So maybe we should ask for it to come back to the committee when the report has been released. We don't have to hear it again. But I know that, I think we've discussed with the author, if there's something in there that needs to be adjusted in some way,
of course,
we would encourage him to look at that.
It would be all right with the committee when we do see the report, we could have that conversation with you and your staff and see where we should go with that. And at that time, we could have that conversation about the sunset possibilities as well as we're looking at the bill again.
Right.
I'm suggesting we might do the sunset now. I don't know that the bill needs to come back at any time short of something very surprising in the DMV report. That would be for you and the chair to work out.
Yeah, I guess I
think so.
Just to make sure that
the next stop of the bill is appropriations.
Yeah. Senator Liu, did you?
It's just that it seems that the bill already has some cleanup clarity to be presented, and then the sunset is going to appropriations if it gets out of today's committee. I would think that those amendments could be taken in the next committee.
If we have your agreement that there'll be a sunset.
I'm more concerned.
In, appropriations,
right.
And then also some of this cleanup language.
When is the pilot program done? Is it?
It was done.
Completed.
It concluded last December, and we extended it last year in this committee for one additional.
For 1 year.
Waiting for the
report. In anticipation of the report, is there any timeline when this report's going to show up?
No.
It was expected several months ago. The DMV is working on it. I've talked to the head of the DMV. They say they're going to get it as soon as they can. I would imagine it would be out in the next month or so.
AB 91 asked for it to be done by December 31st, 2014.
2014 is 2016.
I do have the report that they did come out with, and I wanted to answer Senator Glazer's question. And the first page of that report says the preponderance of evidence from evaluation of effectiveness of IIDs programs in numerous states in the U.S. and internationally have consistently found that IIDs are effective in reducing DUIs as long as they are installed in the offender's vehicle. And I believe it speaks to what Senator Leno said too. When they're used, they save lives.
We can so we will do that, and thank you, Senator Liu, for that suggestion in appropriations and the changes. And I mean, we could, a report back in 5 years, I think would be appropriate. I think that would be fine to look at it and see exactly how it has been successful.
So, Madam Chair, I'll just conclude my remarks. I would feel better with a sunset, but if I'm the only one on the committee who feels that way, that's just the way it is. So I'm going to leave that to you and to see if that's of importance to you or not, and otherwise I'm in support of the bill.
Yeah, okay, I guess I'm concerned about a sunset, a report back, then the legislatures can certainly take action to modify, to make changes, and to move forward as it sees fit in 5 years. I guess I'm always, I look at this as such an important piece of legislation, and we've seen the success of it in 25 other states, and there has not been a problem. And I just want to give comfort to those who have been fighting so hard that they know that they have it in California and not have to be fearful that in 5 years have to have the same battle. But we could certainly have a report that could identify any issues that are raised and address those would be something I'd be comfortable with.
And again, why I feel comfortable with suggesting the sunset is that I don't have any doubts that it would be, again, renewed 5 years if that's the date we're going to use. And I would not suggest a sunset after that we just remove the sunset, not extend it. But that's for future legislatures to consider. Again, it's just because no other state our size has done this. There is no other state our size. It's just such a large, large expansion. That's why I would suggest it. And I would not want anyone, I wouldn't want Mary to have to go home and think, I've got to have to fight this battle again in 5 years. I don't think there will be a battle to fight in 5 years. I think it'll be fairly pro forma, but it's just something we often do when we're doing something new on a very large scale. So I'm not here to impose it on the committee. I'm just
No. I think you're raising a new issue that some of us have not thought about. I think what you're hearing today from the committee is people want to do this, right? Because it appears to be a real barrier to driving while drunk and hurting people. And however, it is a massive expansion. It is a massive economic commitment to an industry, and we want to be careful in doing it and try to minimize unintended consequences. So I just thank the committee for the very thoughtful discussion. I had not thought about a sunset prior to this morning. I know that in general we seem to pass sunsets in a kind of pro forma way generally. When they come up, it might be more appropriate to really have a thorough review of issues such as judicial discretion. I have some questions about some of the financial arrangements and other things sooner than 5 years or 7 years. So we're thinking about it. Senator Monning.
Well, thank you, Madam Chair. I want to thank the author and the advocates for their hard work. I also just want to go on record expressing disappointment that what was postponed for a year in anticipation of getting better data from DMV. We did our part, and for whatever reasons, they weren't able to stick to that timeline. So we're kind of back in the same situation without the benefit of that information. But I'm fully supportive of this today. I think the evidence is clear from other states. The net objective and achievement is to reduce accidents and accidents leading to deaths that are preventable. This technology has been proven to provide that benefit to innocence. If it saves one life, it is worth it. It will save hundreds, if not thousands, of lives. Two just kind of follow-ups. I'm glad to see the inclusion of the sliding scale. Who determines that that cost factor for the defendant? Is that done by the court at the time they qualify for public defender support or whatever?
I would think at the time of the report, there would be a financial analysis that would be done, or a financial statement made by the defendant, and that's when it would be determined.